The signature is admitted, but he claims the check isn't his. This falls under Section 138 of the NI Act. Let's understand the legal implications.
Hello everyone, welcome to Litigants Assam. I'm Advocate Imdadur Rahman, and in this video I'm going to discuss a very important term that is used in the Negotiable Instrument Act 1881. The term that is called is rebuttable presumption. We all heard about the term rebuttable presumption. We all know the term rebuttable presumption, but how the rebuttable presumption is established in a check dishonor case, in a check bounce case. So in this video we are going to discuss the term rebuttable presumption with a suitable example. So the person who gives the check for legally enforceable debt, the person who issued a check to a person for legally enforceable debt, that person is called drawer. To whom the check is given is called pay. So there is no confusion in that. So after issuing the check, if the check is dishonor and within 30 days from the dishonor of the check, the pay sent legal notice to the drawer and gives him 15 days time to repay the debt. If he does not reply, or if he do not pay the amount within 15 days, then cause of action arise after 15 days, then that person can file a case under complaint case under a Negotiable Instrument Act under section 138. So when a check is dishonored and case is filed against the accused, and accused person is admit that signature belongs to him, then it shall be presumed that check is given for legally enforceable debt. So the onus of proof is initially on the accused person. The accused person has to prove that that check was misused, signature does not mismatch, signature is forged, or that check is given for security purpose or other purpose and check was misused. That presumption is on the accused person, and accused person has to rebut that presumption under section 138. Under section 138 of Negotiable Instrument Act, court shall presume that you issued the check, accused person accused the check for legally enforceable debt, and accused person has to prove that presumption is wrong. He has to rebut that presumption. Suppose a person admitted signature on the check, but he says that I do not have any bank account in that branch or in that bank, or that check is doesn't belong to me. I just admitted the signature is mine, but that check is not mine. Then if the court summon the bank manager and bank manager confirms that the check doesn't belong to accused person, or accused person doesn't have any account link with that branch, then the rebuttable presumption is established. Then this is called rebuttable presumption under section 139 of the Negotiable Instrument Act. When rebuttable presumption is admitted, when rebuttable presumption is established, the onus of proof is shifted to the complainant. Complainant has to prove in the preponderance of probability, not beyond a reasonable doubt, preponderance of probability, that the check belongs to, that the check was issued for legally enforceable debt. He has to rebut that presumption. In such way, the onus shifted accused person from the complainant. So we know section 143A of Negotiable Instrument Act 1881. It says that interim compensation to the complainant. So if accused person rebut the presumption under section 139 of the Negotiable Instrument Act, court may set aside the interim compensation that shall be paid during the framing of charges within 6 months of the framing of charge. So the section 118 of the Negotiable Instrument Act and section 138 of Negotiable Instrument Act, the presumption can be rebutted by the accused person. So I hope you have understood the meaning of rebuttable presumption. Thank you very much.